Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hi everyone.
Well, what another busy week. More big policy announcements, more reform and more change on the way. Dennis, I know you've been looking at the latest on pay and income in the legal profession. What have you discovered?
Yes, Helen. Yet more inequalities have been shown up in the latest statistics. Here are the details. Women barristers' average incomes are roughly half those of men, the Bar Standards Board reported last week. Across the profession as a whole, average incomes for women are just 52% of those of male barristers, according to an analysis of income figures for the 2020 and 2021 financial years. The average income for barristers from minority ethnic backgrounds is 68% of those of white barristers. It found that female barristers and barristers from minority ethnic backgrounds earn less than male or white barristers. Women and those from minority ethnic backgrounds also earn less on average than male and white barristers, even when grouped by practice area and seniority, which suggests that differences in income cannot be explained solely by practicing area or experience, the report added. Now, differences in average incomes are particularly marked when looking at gender and ethnicity, together with women from minority ethnic backgrounds earning on average just 41% of white male barristers' incomes when looking at the bar as a whole. The pandemic had an impact on almost all barristers' incomes, the report found, but the largest falls were for male barristers from minority ethnic backgrounds and barristers based outside of London. Now, falls in income were also not distributed equally, with the board's analysis suggesting that the pandemic had more of an impact on incomes at the lower earning end of the profession. Certain areas of practice were also hit harder than others, with crime unsurprisingly seeing the largest falls, while commercial and financial barristers saw an increase in incomes. Sade Kazer, the board's head of equality and access to justice, said that the underlying income gap adversely affecting female barristers and those from ethnic minority groups remains very troubling. These disparities are marked and cannot be explained away by seniority, geography, or the area of law practiced, she added. Now, I've made this point before that inequality in the legal profession is wholly hypocritical, given that lawyers are concerned, amongst other things, with upholding the rights of others in court.
Quite so, Dennis. And reform is in the news this week concerning civil court procedures. As a former litigator myself, I know only too well the concerns practitioners have when procedural reforms are on the horizon. But the Law Society has said it does not believe that now is a suitable time to reform the civil litigation pre-action protocols. In response to a Civil Justice Council consultation, Chancery Lane said this was because many other areas of civil justice are being reformed, and the pre-action protocols work reasonably well in general, although there are some exceptions. The CJC review is intended to make pre-action protocols more effective and streamlined. In November 2021, it published an interim report for consultation on pre-action protocols, of which there are currently 17, including ones covering judicial review and housing. There are a vast array of reforms being canvassed, including online availability, the introduction of mandatory compliance, a good faith obligation, a new summary costs procedure, and new streamlined procedures and timeframes for disclosure. The consultation closed on the 22nd of January this year, and the CJC will review the responses and publish recommendations in a final report in due course. Expressing strong reservations about the practicalities of implementing any such reforms at this time, the Law Society said there are many moving parts in the civil justice system at the moment, many of which overlap with each other. Previous changes need time to bed in and be evaluated before launching into yet more changes. The Society also say that we need to await the outcome of the Judicial Review of Courts Bill, which continues its controversial journey through Parliament. But we will follow all these developments over the coming months. Now, Dennis, you've been looking at the latest guidance from the SRA concerning new duties to support and help staff in difficulty. What's the latest?
Helen, There have been several recent cases where junior lawyers have been penalised for hiding mistakes when working under pressure, but the SRA feel that managers have responsibilities too in these situations. Here's the story. Last week, the Solicitors Regulation Authority announced that failing to provide a safe environment for staff to raise concerns or to admit a mistake could be a breach of SRA regulations. In Workplace Culture, the new guidance published last week, the regulator states that firms should do everything they reasonably can to look after their staff's well-being and protect them from bullying, harassment, discrimination, and victimisation. It expects firms to have effective systems and controls to supervise staff and to monitor concerns which may affect their well-being and competence. The publication follows high-profile cases where junior lawyers have been blamed and indeed prosecuted for covering up mistakes. In several of these cases, the individuals said that they felt pressured by their work environment and afraid to come forward. The new guidance states that requirements include providing a safe environment for employees to raise concerns and addressing them promptly and in a constructive manner. Failure to provide a safe environment may breach equalities legislation or employment law, as well as regulatory requirements. The SRA guidance adds that proper supervision is more than just checking that staff are progressing client matters. It means making sure that, at the very least, firms have in place arrangements for regularly monitoring and assessing employees' workloads and capacity, as well as their competence to do the work. Now, this new guidance raises similar issues, of course, for those who manage lawyers in our sector too. And the problems are also exacerbated as we move towards permanent remote working for at least part of the working week.
Now, the two great policy areas that will transform the future of local government are the levelling up agenda and the drive towards closer integration of the NHS and social care. Both are interlinked. We have had announcements from government on both of these initiatives in just days of one another. So let's turn now to NHS social care integration. Government announced last week their integration white paper to bring the NHS and local government closer together to improve care for all and improve value for money. They say that the white paper sets out a vision for an integrated NHS and adult social care sector, which will better serve patients and staff. In real terms, this involves the integration of both government and local government governance and resources, and therein lies the immense challenge. The white paper sets out some of the ways health and care systems will draw on the resources and skills across the NHS and local government to better meet the needs of communities, reduce waiting lists, and help level up healthcare across the country. The white paper is the next step in delivering the government's promise of a health and social care system fit for the future. It builds on both the Health and Social Care Bill and the People at the Heart of Care white paper, which set out a 12-year vision for social care funded through the Health and Care Levy and follows the delivery plan for tackling the COVID-19 backlog of elective care. Dedicated plans to tackle health disparities are set to be published in due course. But as the debate at our last governance conference revealed, the devil is in the detail. And of the governance proposals that underpin these headline announcements, accordingly, this is an area we will continue to monitor very closely here at LLG. Now, Dennis, you've been looking at a case concerning council liability for employees. What's the latest there?
Indeed, I have, Helen. In a recent case, the question was raised whether special rules apply in certain cases. So here's my analysis. When is a council liable for the wrongful acts of its employees? Now, this question arose in the recent case of Ali against Luton Borough Council. The leading case remains that of various claimants against William Morrison's supermarkets. And the judge said here that the issue fell to be determined by applying the law as declared by the Supreme Court in the Morrison's case, and in particular the test reiterated by Lord Reed. He said, in a case concerned with vicarious liability, the court generally has to decide whether the wrongful conduct was so closely connected with the acts which the employee was authorized to do that it may fairly and properly be regarded as done by the employee while acting in the ordinary course of his employment. Now, this case involved the unlawful acts of a social worker, and interestingly, it was argued against Luton that the question depended upon the nature of the role and the duties entrusted to that particular employee. But in reaching his conclusion, the judge said here that the employee was in no way engaged in furthering the business of her employer when she unlawfully accessed and processed confidential data from a casework file. Now, we can take from this case that the nature of the information, or indeed the role of the employee involved in a particular case, will not override the tests for vicarious liability as set out in the Morrison case.
Thank you, Dennis. Well, followers of our coverage of the government's reforms of judicial review will not be surprised that these proposals have now come up against severe opposition in the House of Lords. The government's controversial reform of judicial review faced significant amendments in the House of Lords after peers raised concerns about the new remedies available to the courts and the abolition of certain appeals from upper tribunal. Labour opposes the judicial review reforms, with Shadow Minister Lord Ponsonby telling peers that the Ministry of Justice is trying to fix something which is not broken. He also raised concern that the government will use abolishing CART as a precedent to abolish other types of judicial review. Leading public law silk Lord Panic warned that suspending quashing orders gave the judiciary a remarkable power, meaning people who have suffered loss or damage by reason of an unlawful government action would be denied compensation or damages for that wrong. Lord Etherton, a former Master of the Rolls, predicted that the mandatory provisions in the bill relating to quashing orders would unleash a plethora of satellite litigation and appeals. Whilst Shadow Attorney General Baroness Chakrabarti said the government is attempting to bind the hands of courts with a presumption towards prospective-only quashing orders. Once again, LLG will continue to keep a close watching brief of this important area of the law for practitioners in our sector. Now, finally, if you're a childcare lawyer, I really want to hear from you in respect of kinship carers and the lack of legal aid impacts to inform evidence LLG are giving to an all-parliamentary group. So please do contact me directly, and also look out for a roundtable happening next week. So that's it from us for another week. It's goodbye from me.
And from me too.
Thank you for listening. Have a good week, everyone.